So Chris, as we get started, would you explain for us why we even have a license law? What's it there for?
Happy to. The legislative intent, and that when I say legislative intent, the license law is passed by the General Assembly. We have the act passed by the legislators, and then we have the rules that is done by committee. The intent is to protect the consumers that we serve. Everyone knows that housing has a huge impact on the economy of Illinois. And in order to prevent misunderstandings of the people that we serve, in order to promote stability within the marketplace, our license law is designed to do just that, to protect the consumers that we serve.
Okay. All right. So what about some of the changes? Does it change? Does it stay the same? How does all of that work?
The license law is designed to sunset every 10 years. Why? Because the legislators want to make sure that we are keeping current with the trends in the marketplace. As you know, in 2010, there were some major changes, mainly from the education perspective, new brokers that came in, or we changed the managing broker and the managing broker license was designed to address the lack of supervision. And the number of hours to get a license was changed to raise the bar for competency level within the industry. So and how does that happen? Well, so when 2020 and 20 was coming about, there's a lot of industry people that get together. They discuss, they brainstorm, they negotiate with the department. What are some of the trends that our license law is not addressing? And so there's a lot of negotiations and discussions within the industry as well as the department to come up with, to present to the legislators, this is the changes that need to address for the current times.
Okay. Well, it's good to hear that things don't just stay the same constantly. So what kind of changes have we seen recently?
Well, a couple things. First of all, as far as for new licensees, you now will be able to be 18 years old to get your license. It used to be 21, now it's 18. And to get a managing broker's license, obviously you have to have a license for 2 years, so 20 would be the minimum age to get a managing broker's license.
Okay.
The number of hours is changing. It was changed to 90 hours plus a 30-hour post in 2010. What is happening in 2020, it's going to be 75 hours to get the license, but 45 hours post. So it's still 120 hours, but we have found that post-license education is so much more valuable to the individuals. They've been out practicing a little bit. They're not overwhelmed by all the terms, and they get so much more out of it. So that 45 was pushed to that okay. side of it. So from the new, and by the way, the managing broker, changes for the managing broker are now going to have to maintain even stricter supervision until that new agent completes that 45 post education. They're going to have to be really staying on top of those individuals.
Okay. Okay.
Other changes that are going to impact everybody. You don't have a pocket card anymore. We still have the obligation to make sure that you keep identification on you at all times. So whether you're taking your license and taking a picture of it, you're printing it or whatever, but you still have that requirement to keep that on you at all times.
Can I ask a quick question? We just heard just recently of the police when someone was showing a property. The neighbors called, it was a vacant house, and the neighbors called and reported it, and the police showed up at the property. Mm-hmm. And one of the first things the police asked for was identification, pocket card, something. We're not going to have one anymore. What's your recommendation for the agents?
And that's a classic example why
right.
you need to have that information on you at all times. I have mine on my phone that I carry with me at all times. I also have one printed that's in my wallet. So okay. I have double on that.
Okay. Good.
Right.
Good.
Other changes coming up that were addressed, teams, we're going to be talking about this in this course, some license law issues that are addressed in teams changes, which also are going to impact on advertising changes as well. So definitions, the designated managing broker versus the managing broker. It was the named managing broker. Now we're going to refer to it as the designated managing broker. So, couple of other things. Citations. The department is now going to have the ability to issue a citation when they're on non-compliance of CE. Before, they had to go through the regimented process, hearings, et cetera, going through the prosecution stage of the department. And now it's going to be much more simplified. If through their audit process they find that someone is not compliant with the CE, they're going to be able to issue a citation. Always have the ability to ask to defend yourself, but the department will have a streamlined process for that.
So what kind of disciplines have we been seeing recently coming down from IDFPR?
Good question, and they publicize these disciplines. And keep in mind, again, the legislators want to make sure that we're protecting the consumer. So discipline is designed to address non-compliance with the license law. We've included in this course some of the top disciplines in the last year. I think every single licensee should take a look at that, should understand that you do need to be accountable for making sure that you're in compliance. The list that's in your course material are samples. I mean, every case is going to be different. Every fine's going to be different, but it's going to give you a good indication as to what some of the problems that some of the licensees got into.
Okay, thank you.
Please pause the video, go to the Business Issues and License Law module, take the Business Issues and License Law quiz.
Okay, now that you've taken your first quiz, let's go over that quiz about business issues and license law. And I will give you the correct answer and give you a little brief explanation on each question. So our first question is, a licensee must inform the department of an address change and or email address of record change. So basically what we're saying here is, how long do you have to let the department know that you have either changed your address, your physical address, or your mailing address, or even your email address? Because now that the department is doing all of their communication by and between the licensees with email, it's imperative that they have the correct email address for you. So the correct answer is within 24 hours. The point there being that this was a recent change with the amendments that were approved and written into the law in 2019, effective immediately. And it's really not that difficult to do. You can do that on the online portal and go in and change your email address and your physical address as well, or any other information change that you may need to make. So you have to do that within 24 hours, of the change. Question number 2, when issuing a leasing agent student permit, the designated managing broker must certify that, and the correct answer is basically all of the above, that you've not been a permit holder within the last 2 years, that you've not had an actual residential leasing agent license within the last 2 years, or you are or will enroll in a 15-hour required pre-license course within 60 days. So that's the answer, is all of the above. Number 3, a licensee must have a written employment agreement with a sponsoring broker, even if the licensee is an independent contractor. And the correct answer is true. The sponsoring broker is required to have written either employment agreement and or independent contractor agreement with all of their sponsored licensees. And there are requirements that have to be met within those agreements as to compensation, termination, and policy and things like that. So all of that has to be done in writing. So you must have a written employment agreement or an written independent contractor agreement with your sponsoring broker. Number 4, compensation must be paid through your sponsoring broker. Which of the following would be an exception to that rule? And the correct answer is C, commissions earned while working for a previous brokerage or sponsoring broker. So what this, a good example of that is, let's say that you have changed offices, but you had an accepted contract that had not yet closed on one of your listings. Then your previous sponsoring broker can pay you for that transaction or those transactions that were pending or had not yet closed prior to your leaving. So they can even pay you if you're sponsored by another broker at that point in time when the closing occurs. Question number 5. Licensee Lewis is sponsored by ABC and has his own LLC. He can, and the correct answer is, receive commissions from ABC to his LLC. There's been a couple little changes in that for probably the last 20 years. A sponsored licensee could form a corporation that was solely and wholly owned by that sponsored licensee, but they have extended that also to LLCs if they are properly structured. And now, with the amendments in 2019, you can even have an LLC or a corporation that is owned by a husband and wife, as long as both are sponsored licensee of the same sponsoring broker. It's a little bit nuanced, but it would allow a husband and wife who work together as a team in real estate to form a corporation only for the purposes of receiving compensation. But it is rather nuanced. So yes, they can, but that would be the extent of that LLC or corporation. Number 6, licensee Alexander Smith goes by Alex Smith. To be in compliance, he must obtain and record an official DBA with the department. And that is false. Now, if you are using a diminutive of your first name, in this case Alexander, and that's how your license is issued, you can send a written notice to the department that you are using a diminutive of your first name and that you would go by Alex. And then that would put you in compliance, and so you could advertise by using the name Alex and would not have to use Alexander. And it would not require that you file with the county clerk for a DBA and then get it certified and then send that. And that only applies to diminutives of your first name. Okay? Number 7, an unlicensed assistant may do all of the following except, and the correct answer is manage a shift at a home show booth, because that would require a license, and that is considered a licensed activity because you would be meeting the public at that home show. So that would require a license. But an unlicensed assistant at the direction and at the supervision of a sponsored or of a licensee may complete or fill in the blanks on a contract at the direction of the licensee. They could handle details for closing, such as schedules and things like that, and they can compute commission checks. So none of those other 3 are actually considered to be licensed activities. but managing a shift at a home show booth would be. And that would require a license. And question number 8, a licensee, a licensed broker or managing broker may auction real estate without a real estate auction certification. But an auctioneer with a real estate certification may not perform brokerage activities, and that is true. So the correct answer is true, and if a broker or a managing broker is selling real estate at auction, that is considered a licensed activity under the Real Estate License Act, so they have a license to do that. Now, there is a provision in the Real Estate Act that allows a licensed auctioneer to obtain a real estate certification, and what they basically can do is work in conjunction with a real estate broker to call the sale and even assist a little bit in the advertising. But that requires a special certification, which is a 30-hour course, and so they could not perform brokerage duties with that certification. Only a real estate licensee can do that. Okay? So that's our quiz on our business issues and license law and an explanation. Thank you. Now that we've completed the quiz and also listened to the discussion between Chris and Lynn about those license law changes and some of the other aspects about disciplinary issues and things, now I want you to look at those case studies that are on pages 6 and 7. And what I'd like for you to do is to read each one of those and go through and then just jot yourself some notes on what might be the correct answers. And then when you get through all of that, then we're going to have Chris and Lynn come back and they will give a further explanation of those case studies. Thank you.
Please pause the video. Go back to your coursework, to the Business Issues and License Law module. Read and think through the case studies on pages 6 and 7 in the Business Issues and License Law with Case Studies section. Remember, case studies are independent exercises not completed online.
Hi, Chris Reed. Going to go over the case studies for the license law segment, starting with case study 1. So if you're looking at this, let's just review some of the facts. We're talking about teams needing an office space, and we're seeing this in the marketplace a lot, where teams are wanting, because they do a lot of communication together, they do activities together, and many offices don't have the space to give them. So they go out and they rent their own space. Their cards say their office space. They meet clients there. This is acting as a branch office. Now, there has been a change. Actually, this happened previously in 2018 and became effective January 2019, that we did away with licenses for the branch offices, but we still have to have them registered. So if a team is going to have their own space, meet their clients there, have their address on there, it needs to be operating as a branch office, which means that it has to have the correct signage, has to have the name of the sponsoring broker be very clearly identified with the sponsoring broker, and have a designated managing broker overseeing and supervising that location as well as their others. That's the main purpose of that case study. This has to do with an agent leaving one office and going to another one office, and we have seen many, many issues with this. The agent Andy is leaving ABC, he's going to XYZ. If he has 3 listings, he has 2 buyers, he has no buyer representation agreements, and he has 4 transactions waiting to close, and 2 sellers ready to list right now. So let's talk about, first of all, can he take his listings with him? The answer to a lot of these questions, it's going to depend upon your independent contractor's agreement. Every company is well, from a perspective of if you're acting as an independent agent, that you have to have an independent contractors agreement or employment agreement. Both of those are referred to as the same. Termination proceedings are going to be outlined in that agreement. Some companies will allow an individual to take the listing, but the listing is signed by the brokerage company. The brokerage company, the sponsoring broker, is the one that owns the listings. So in most cases, those listings must stay with the brokerage company. Again, your ICA agreement, independent contractors agreement, is what's going to be answering these questions. Same thing with the buyers. Now, if there's no buyer's agreement and that managing broker didn't sign that buyer's agreement, it's going to be kind of hard for them to know what buyers that someone is working with them. But take, for example, if that agent had received a buyer from their relocation department, or it was assigned as a referral or whatever, absolutely that buyer would be remaining with the company, again, unless it was negotiated with the managing broker or outlined in the independent contractors agreement. Pending closings, folks, that contract was done with the ABC sponsoring broker. ABC brokerage is the one that is responsible for making sure that that transaction gets closed properly in a timely fashion. So that sponsoring broker is the one that should be closing it out. Now, if there's other arrangements that are made, that sponsoring broker needs to make sure that they are continuing to supervise and to make sure that the agent that left is closing it out properly. If something is lost in the transition, that consumer is the one that is harmed. So we need to make sure that the consumer is protected and that transaction is handled in the proper way. What about this question about he's got 2 pending listings? So he gets his new managing broker from XYZ to list it, and he handles it, but he just has the listing, the new managing broker sign it. A huge violation. Huge violation. What should he have done? Should have referred them, have the managing broker take care of it from the get-go, and not have his name on that or his involvement on it at all until he gets over to the new company.
This was about multiple offers, and we had a buyer broker who was told there were multiple offers to bring his buyer's highest and best. And later they found out that there were no other offers. So the buyer got obviously a little upset about that. So the questions that we looked at there were, should the listing agent be held accountable for giving out false information? And how could the buyer agent have protected their client a little bit better in this situation? So let's start with the listing agent. Yes, absolutely, the listing agent is in violation of, I would argue, both the license law and the code of ethics by giving out false information to the buyer agent about whether or not there were multiple offers. If there are multiple offers on our listing, the first issue is that we do not have to disclose there are multiple offers. That is up to the seller to decide whether or not we disclose it. But absolutely, we cannot lead the buyer agents to believe they're in multiple offers when in fact they are not. So the listing agent in this case was not in any way doing the right thing. So the second issue then is, how can the buyer agent protect themselves or their clients in the future? In the code of ethics, and it's the code of ethics that has more to say about this particular issue than the license law does. But in the code of ethics, it says that I, as a buyer agent, when I am told that there are multiple offers, I have the right to ask the listing agent who has those other offers. And that was put into the code of ethics a number of years ago for this very reason. If you tell me that I'm in a multiple offer and I say to you who has the other offer, you now have to lie to me again. And you now have to make up something. You now have to say, because when I ask you, you have to tell me whether it's you, the listing agent themselves, or someone from your office, or is it another co-op broker. You do not have to give me the name of the co-op broker, just the category. In other words, co-op broker is someone from your office or you. So when I ask you the second question, okay, you told me multiple offers, I say who has the other offer, and then you start stumbling over your words because there's no answer for that. You don't have another offer. That's when most of the time the listing agents will start to tap dance and they'll come up with, well, we really don't have the other offer yet, we're waiting for it, etc. We need to know what the rules are. It's the rules of engagement when it comes to negotiating contracts. So listing agent, no, you cannot lie about multiple offers, but the listing agent does not have to tell you they're in a multiple offer either. If the seller says, I don't want you to disclose multiple offers, then I, as the listing agent, do not have to tell you. If you ask me, are we in a multiple offer, I cannot lie to you again. I cannot say you are not when you are, just like I can't say you are when you are not. So if you ask me, are we in a multiple offer, and my seller has said, I don't want you to disclose it, then I would have to say to you, I'm not at liberty to disclose. It's real important then in this case study that you understand how the issue of honesty plays out, because it is a violation of the license law to mislead, to lie to someone, even when you're negotiating contracts, even with the idea that, well, my lie is in the best interest of my client. Nowhere in the license law does it give us permission to mislead other people in order to advance the position of our clients. This has everything to do with obeying the lawful instructions of our clients. That is our duty as an agent, but the word lawful needs to be remembered as we go through this one. So we had a contract that was executed and it was delivered. The earnest money was not tendered as the contract called for. So the seller didn't want to kill the contract because the earnest money was not there, which, by the way, they could have. If my buyer does not deliver his earnest money, or I don't deliver his earnest money to the listing office, if they are the escrowee, if that money is not there as per the contract, my buyer is now in default, which gives the seller the opportunity to be able to terminate that contract for default. It's not an automatic termination. It would give them the opportunity to do so. This seller chose not to do that. This seller said, I want to give this buyer more time, but now said to the listing agent, I do not want you to report to the MLS or tell anyone that we've got a contract on the property, because what if this first buyer never brings in the earnest money? Well, I think the phrase that's probably running through your heads right now is you can't have your cake and eat it too. Mr. and Mrs. Seller, you have a decision to make. I, as a listing agent, do not have to follow your unlawful instructions. My MLS requires me to report to the MLS that the property is under contract within a finite amount of time. Whatever that time frame is, it's going to be different for all of you, different MLSs. But I have to report that it's under contract. But beyond that, the Code of Ethics requires that I disclose to anyone seeking cooperation to show this property that there is already an executed contract on the property. Because right now, if I don't tell anybody that there's an offer on this property and you write a contract on it, you and your buyer are expecting my seller to be able to sell their house to you. They can't. You would have to be a backup contract, subject to us getting rid of the first contract. The second buyer has a right to know that. So we've got a seller here who is asking the listing agent to violate their ethics, to violate their MLS rules, and that is not something that we should be doing. It's our responsibility to say, Mr. and Mrs. Seller, you got a decision to make. We're either going to, if you choose to terminate this first contract because the buyer's in default, then I don't have to tell anybody we've got a contract. But if you choose to keep that contract in place, I am going to have to disclose that. So again, it's not a matter of I'm going to do everything that my client's asking me to do. Everything I do has to also follow the license law, the code, and any other rules like your MLS rules. This is something that we deal with quite often when we look at buyer representation agreements and compensation. So in this case, Bart had an exclusive buyer representation agreement with the buyers. Bart sold these buyers a property they had seen with another agent prior to Bart having them sign an exclusive agreement with him. After the transaction closed, the previous brokerage company filed for arbitration because they said they were procuring cause. They were the ones who showed the property to the buyer. They won. All right, and again, we're not taking a deep dive here into the procuring cause issue. We're here to talk about a different aspect of this, and that's whether or not BART has any further recourse for getting compensated. If I have an exclusive buyer representation agreement with my buyer, it means that my buyer is going to owe me the compensation if I sell him a house during the terms that fit the terms of my agreement. BART did sell him a house that fit the terms of that agreement, but most buyer representation agreements have a clause in them that says that if there is a property that I'm going to show to my buyer that does not pay me from the listing office or from the seller, if that property, if they're not going to compensate me at the level that the buyer owes me, then I have to disclose that to my buyer prior to my showing him that property, because that buyer has a right to say, if the listing office or the seller is paying X and my buyer representation agreement says I get double X, then my buyer's responsible for some part of that double X. He has a right to say, I don't want to look at that property, show me other houses, so I have to tell him. In this case, I didn't tell him he owed me any money. I said it was all covered in his offer to the seller. And now after I lose in an arbitration hearing, I'm going to come back and try to collect from my buyer. May I say to you, ladies and gentlemen, that the problem you're going to have is it's going to be very difficult for you to collect on this one, because you gave no notice to your buyer prior to showing that property that he was going to owe you any money. But a secondary part of this one is way too many buyer agents believe that I don't care whether or not my buyer saw the house with somebody else before I came along. Once I have them sign an exclusive buyer representation agreement with me, then it wipes out any claim a previous brokerage company has to procuring cause, and it does not. The buyer representation agreement does not negate the fact that that first brokerage company had a right to go after that for procuring cause, and whatever evidence came out in the hearing led the hearing panel to rule for the first brokerage company. Got to be careful here, guys. A buyer representation agreement, an exclusive buyer representation agreement, does not automatically mean that you are going to get paid on a real estate transaction. You still have to do your job.
Commercial issues. BART has never handled a commercial transaction in 20 years. He's been a licensee for 20 years and he's never done anything along the commercial lines. A family member asks him to list their retail space for rent. The owner wants to market it as a triple net lease. BART has no idea what that means. How should BART proceed? The intent here on this case study is, again, I know I've said this a couple times, but you have statutory duties as a licensee. Exercising reasonable skill and care is one of those important statutory duties. Commercial transactions have its own skill set. And when we have people that are very good at residential and they try and do commercial, many times they don't have the skill set and they're not acting in the best interest of their client by trying to do the commercial. Sure, you have a license, there's no such thing as a commercial license, but you don't have the skills for it. So what BART would be in promoting the best interests of this family member, his best move, his best practice would be to refer it to someone who does have commercial experience. Now that referral could be something that maybe he's going to stay involved. Maybe he wants to be a part of it. Maybe he wants to sit on the sidelines or whatever, but that would have to be up to the person that he's referring it to and what kind of an arrangement that they're going to make. But exercising reasonable skill and care, promoting the best interest, put their interest, the consumer's interest first before trying to chase the money and working something that you don't know how to do it. Alex set up his own property management company. Called it Muscle Management. He actually went and got it approved with the Secretary of State, set it up as an LLC, but did not go to the next step and register it and get it licensed from the department. So he and his wife are managing 75 properties. Wow, huge. They're very successful. But there's an issue. It's not licensed with the department. The second issue is that Alex's license, he does have a real estate license, and he's sponsored by ABC Brokerage. ABC Brokerage has no knowledge of him doing this property management activities on the side. ABC Brokerage, who's supposed to be supervising Alex, is clueless. So what would have to happen in order for this to be done correctly? Well, if Alex was doing property management under his sponsoring brokerage, obviously he'd have to have permission from his brokerage. He'd have to make sure that all payments, etc., commissions were going through his brokerage company. Brokerage company might question, or do they have E&O insurance to cover property management? There would be big issues on that, or questions on that the company would want to be looking at. Or Alex should have had that company licensed, which means that he could have taken from the Secretary of State, had that, and then gone to the department and have it licensed. Obviously, he would have to have a managing broker to be operating, to supervising that company. But here's another issue. Can Alex own and operate and work muscle management if it was legally licensed and still be sponsored by ABC? And the answer is no, because you cannot be doing licensed activities for two sponsoring brokers. What about ABC Brokerage? Could they be held responsible for this issue of unlicensed practice? And the answer is absolutely yes. They have sponsored Alex, and the fact that they knew nothing about what Alex was doing is an issue. You know, what's the communication? How could they not know what Alex was up to? So they could definitely be questioned and having to defend themselves that it was totally Alex, a renegade agent, but they'd have to really be defending themselves that yes, their company policy says no property management, and make sure that they are clear of their supervision and that we just had a renegade Alex off on their own.
You can now close the Business Issues and License Law video guide, go back to your course, to the agency module, read the pages on agency. After reading the pages, please go to the agency video guide.